Good. So welcome to everybody. Thank you for being here. This is our third and last event of the Alterfestival in Turin, and we are having a very interesting guest, who is Prof.Avi Singh, who is a scholar from Delhi. He's been a long time friend of mine. Also a student of mine many years ago. Then he moved to international criminal law. He was at the Arusha tribunal for a while, and then he went on the Sierra Leone case on behalf of Mr. Taylor. And then he moved back to India to accept a position as the Deputy Solicitor General of the city of Delhi, which is not like a local job. I mean, the city of Delhi is larger in terms of inhabitants than Torino, and it's basically a government position of high level. And he's been a practicing attorney for a long period of time, and we've been working together on issues of comparative international law for quite a while. So I'm really very grateful to be here with Avi. I kind of invented the title of the speech without mentioning it to him, which was a little bit an essentialization of his coming from India. So he said, well, what is international law and the crisis of international law seen from the perspective of the Indian subcontinent, which is which I thought was an interesting topic, especially because I have no idea of what's going on, and I have a fascination for what's happening in the domain of the BRICS, which seems to me the only or one of the most important avenues that are beginning. However, you know, whoever is not from the area that involves the BRICS, so someone who is who looks at things from the West in my position, I'm less than certain that the political relationship between the members of the BRICS are so wonderful. There have been very serious tensions, for example, that everybody knows between, just to talk about what we're talking about today, between India and China, that are still, I think, we will hear what is going to happen. And so I thought that it was interesting to see what development we can foresee in international law from the perspective of someone coming from the BRICS that has an education and the practice in international law for a long period of time, and that knows very well also the situation here in the West, having been a professor at the IUC for the last 15 years or something like that, right? From the very beginning, yeah. So without further ado, and also let me take the chance to thank also for being here, really surprised, Professor Leo Gangua, who is sitting there. So we have from the University of Lanzhou, who is also a longtime friend of mine, also a former student of mine, and also a friend of the IUC. And so he was on his, you know, in some sort of traveling in Europe, and he thought to come and visit us. Was really surprised and so welcome, and very happy to have you here. So without further ado, Avi, you have the floor. We can have it conversational if you prefer, or we can have it lecture-wise or whatever. We are among friends.
Yeah, and any questions on China come to you, huh?
Yeah. Exactly. Or maybe that's why he's here. The party is here to check what's happening. Good. Yeah, that's it. Could explain the coincidence.
Yeah, you know some things, you know that. Yeah. So, okay, so shall we do it as a conversation? Okay, but let's, I think, talk about, perhaps you can start, is the state of international law. And we don't have a screen, but I will just hold this up. This is the headline, I believe it's a Jordanian paper. It is a picture, it is from the end of 23, so the situation has only gotten worse. Let me just make it a bit bigger so people can see. This is a rubble in Gaza. And the headline in Arabic, I'm presuming the translation is not wrong, is the rubble of international law. So the law exists with some consent, I mean, all the law professors, students also, with some consent of the people it's subject to. So where you have in Jordan or on the street the headline which says, this is the rubble of international law, then some of the courses, like been teaching transnational litigation, as Ugo said, not from the beginning, but almost from the beginning, and we always talked about the crisis of international law, right? And now, and in fact, this Arabic scholar, Atar Hindi, uses, if you allow me to steal his language, a song by the rap artist in 2006 called Nas. I'm not going to try and sing here, but it says, it ends with, it's about the end of rap because it's become too commercialized. So we all gather here for the daily departed. So international law, as we understand it, because we are still practicing it, is to some extent no longer able to hold its contradictions. They have become too large and too hypocritical to say that there is a rules-based system that everybody needs to follow. And I don't mean only for the law of war or the law of aggression. It is truly now we are in a state where the legitimacy is very hard for anybody to argue that there is legitimacy to a rules-based system where you have, of course, some sort of nationalism coming everywhere, but you really have a system of what applies, where it applies, being completely separate, right? And this is, of course, exacerbated by the treatment on how we deal with this new legal regime, which is emerging, which I'm fascinated with more, and how in international law we deal with it, which is almost corporate law. And by corporate law, of course, I don't mean company law, because everybody teaches that, but we all live in some sort of company-made law, whether it's on the computer that some of you are on our phones, or on our international systems, or when we're dealing with these states which are now corporations, UAE or Qatar. They're basically corporations. They're governed by corporations which control all the state assets, whether you fly to United Arab Emirates or support PSG, etc. So we're dealing with states functioning as corporations, but the international law has very few mechanisms, has never had mechanisms, but now the situation has gotten to another level to deal with. So we're talking about, of course, the debris or the rubble of international law, which has only been accelerated by the war in Gaza, or the massacre in Gaza, if you can call it that.
Yeah. Well, it seems to me that there is, to start from, so where international law comes from and where the classic points. And we know very well that international law after World War II, so we are in a very, very recent phase of the development. The United Nations system was created in order to take care of the shortcomings of the Society of Nations. The Society of Nations was incapable of granting any sort of principle to avoid the conflict of World War I. Okay, so there was, we are talking about a 100 years history, okay, of international law as we understand it. Before that, of course, there was international law from the times of Ugo Grotius. So we're talking about early modernity, but that was a model of international law that in a way or another was already corporate. It was already an international law for corporations rather than an international law for states. We were in the sort of moment in which the large corporations were developing as agencies of imperialism, and international law was born as a way to ascertain the fact that the Western European states could organize themselves through corporations in order to extract value in India or in Latin America or wherever. But that is, in a way, an early origin. But when we talk about the crisis of international law today, it's not the crisis of international law made by corporations. They thrive. They thrive. They are very, very happy if international law made by states doesn't work. Mr. Elon Musk doesn't need international law to throw his own, rockets in the sky, and he would take control of an area where there is no law. It's a huge common, right? So the less there is law, the more, if you are in the mental state of a tragedy of the common, you can occupy it. So that's not what we discussed today. Today, it seems to me we're discussing something very different. The failure of the attempt after World War II through the United Nations to organize some sort of a centralized system of international law based on an idea of sources of law, that is to say a hierarchy of principles and rules that articulate with each other in some kind of order, accompanied by a quasi-government structure of institutions and bureaucracy. So we had, as you know very well, an International Court of Justice whose Article 34 contains the sources of it, the sources of international law, describes what can be considered the binding sources of international law according to a court of law. That was very new. There was never a court that would adjudicate on international law in the very sense in which a national court would work. Then there would be, as you know very well, there was a creation of the General Assembly of the United Nations, in which the principle, this is the real hypocrisy, it seems to be, the principle of state sovereignty and the fact that every state is equal to everybody else. So this is the idea of formal equality between the states looks very weird. But maybe it's not more weird to say that, Elon Musk is equal to any guy who is sleeping as an homeless in the street. It's pretty much the same thing. According to the law, principle of equality doesn't assume any material condition. Therefore, it's not more absurd to say that the United States and Belize are the same thing. That is to say that Mr. Agnelli is the same thing of his employee. You're simply talking about differences in terms of material conditions that are so huge to put into question the very possibility to talk about equality. There was this decision of the U.S. Supreme Court day before yesterday on homelessness is absolutely the best example. You do not have, is there a right to be homeless? Is there a right to sleep in the street? Is there a right to, basically bring your body wherever is possible? And before there was this idea, there is a right to be homeless, everybody has a right to be homeless, so Mr. Bill Gates can sleep under a bridge as much as the homeless person, and therefore they are equal. Now they are not even equal anymore because you do not have a right to sleep in the street. If you are a homeless person, basically you'd better stay awake, otherwise you end up in jail. So these all things are becoming very difficult to maintain. But anyway, the system of international law started on this idea of sovereign equality, which means that every country has a vote in the Security Council, in the General Assembly of the United Nations. One means one. And then, however, there is an executive, which is the Security Council. And the Security Council was reserved to those countries that came out on the right side of history after World War II, okay? In particular, there were the United States, they were Soviet Union, now subsequent successor country, which is Russia, China, then there is France that found its way within the Security Council, even if they won the war. They surrendered after 15 days, but they surrendered in a nice way. And then there is of course Great Britain.
Yes.
And who else is there?
That's it.
Okay. So this is like the government in a way of international law, and this government of international law works on an idea of veto power. That is to say, whenever the General Assembly moves for something, they maintain a power to veto what the General Assembly did. Okay? because the General Assembly might be too much democratic, perhaps, or too much in the interest of the whole world. So basically, every time in which there was, in the case of Israel, is the most famous 82 resolutions, I think, of the General Assembly, each single one of them vetoed by the Security Council, because the United States have been exercising the veto power in behalf of Israel constantly since the foundation of the state, with the exception, and this is I think this is a point that makes this conversation interesting, with the exception now of Gaza, because for the first time there was no veto by the Security Council on the deliberation on the ceasefire. Okay, so this could have been a turning point. So we have basically a system of international law that is trying to centralize power in certain ways, but it seems it doesn't work. And it seems that it entered into crisis very dramatically from 2022 with the Ukraine crisis and not with the Israel crisis, because that was always there. It was not a crisis really, but with the carnage in Gaza. Yeah.
I mean, in addition to the Security Council, of course, there is the provisional measures of the International Court of Justice in the case brought by South Africa, which basically accuses and is found to have some prima facie finding that Israel is committing genocide, which of course requires a specialist intent in Gaza. And if the first provisional measures, which required them to maintain humanitarian aid, in which even a survivor of the genocide in Europe, who was Justice Barak, who was the ad hoc judge from Israel, agrees. He doesn't agree, of course, to the central ones. But the second provisional measure said you must have ceasefire in Rafah. So now you have the Security Council, the two institutions that Ugo mentioned, which are binding, the Security Council and the International Court of Justice, both and the General Assembly, both saying stop the war. And you have the so-called principal flag bearer of international law, of course, and principal violator has always been the US. That contradiction has always existed. The most wars, but also the person who insists that in the Russian-Ukrainian conflict, that you must comply with the idea of sovereignty, etc., is the US, enabling and actively helping the violation of international law. So then the question becomes the headline, which is the rubble of international law, and the idea that international law doesn't exist for the global south is there. I mean, today, if the American ambassador, and pick a country, goes and says, we are for a rules-based order, and Russia, for instance, I'm just picking an example, is violating international law, I'm not going to say but. You can't say that, because international law requires that the argument be coherent. Some, of course, there's always hypocrisy, but law requires some level of coherence. You cannot have complete hypocrisy and complete deviation.
Yeah, but we have to add a bunch of other things. For example, there has been the crisis of, let's call it the UN Charter model, okay? The one that I've been describing, what came out from San Francisco in 1948, right after.
45, it starts, right?
45. Yeah, 45.
By the way, when China is Kuomintang, which is important to remember, India is still a colony.
Yeah.
So most of the G20 are not actually independent countries. They're not signatories to the Charter as independent countries.
Yeah.
So that's an important part of the foundation of modern international law, is deeply colonial in its character.
Yeah, definitely.
Yeah.
Definitely. But that system was already in crisis before.
Exactly.
And it was already in crisis because it looked like it was not functional. Okay, so international law developed all bunches of other pieces in a very pluralistic way. You know, whenever there is a centralized system that doesn't seem to work, then there is a proliferation of subsystems of a kind. Okay, so we had the International Criminal Court, for example. That is another joke, but also, you know, arrived out of the sense that there was not enough in the usual pyramid. Then there is, of course, international law was also based on the WTO.
Yes.
The WTO was creating a system of global economic international law. Again, for a while, you know, between 2000 and 2022, it could have been completely possible to say that the WTO was the only system of international law that was actually working with its system of retaliation. Now also the WTO doesn't work anymore because, of course, when the tension arises and then protectionist measures are rampant everywhere, the WTO, nobody talks about the WTO
because America
anymore.
turns against it.
Exactly.
Started in Trump. But all of this, so there is the idea, because today, of course, what is talked about is sovereignty. In Ukraine especially, the idea is that sovereignty, unlike bell bottoms, is back in fashion, right? 70s, the new economic order, which is of course a very much a decolonized initiative, comes up which says sovereignty, and sovereignty over what? Your economic resources is the bedrock of international law, right? So the new international economic order resolutions of the General Assembly say that we must have control over our economic resources. Since the 70s, of course we're generalizing, till today, the entire international economic order has been about undermining sovereignty with debt relief, with WTO, with the other institutions that have been working very efficiently.
International human rights.
Yes, international human rights, but also bilateral investment treaties, which basically transform private obligations into international legal obligations. So all of these institutions, and then of course, we cannot forget the human rights, which leads to the right to protect, which leads to the bombing of Libya. So everything is about sovereignty is a bad concept because it does not allow the individual right to human rights and development. It's contrary to that. But now, when we come back to the protection against aggression, we are back to saying sovereignty is inviolate till Israel happens. Now we are not talking about sovereignty anymore. So again, the dysfunction is very apparent and very large.
Yeah.
Right? And just going back to your comment on Grotius, I mean, Grotius, of course, in his conceptions also, in not only corporate, but also enables a sense of colonialism. Because if you say that modern international law allows treaties and allows even you to delegate your freedom, your sovereignty. This starts with Grotius, right? The idea that you could sign away, a Native American tribe could sign away its land and its freedom entirely through a private contract, which then had to be honored, or face international law, or in the context of the opium wars in China, in the name of development and free trade, you could have a war based on enforcing an import of drugs, narcotics.
Yeah.
Right?
Well, but that's historically the connection between modernity and the belief in technology. So the idea basically of international law was whoever has the best warships has might makes right. So if you have enough weapons and enough technological development to be able to go in Africa to capture some people to sell them on the market in the United States or in Brazil, you can do it, and that's fine. Go ahead, it's free trade. So that's the idea. And the law will protect whoever will try to limit this freedom, which is the freedom to take, basically the freedom to plunder, the freedom to, So the idea it was that international law was there to protect the absence of law, somewhat paradoxically, right?
But enforced with a creation of a public/private property or international private property through some kind of international legal treaty. So if there's in South Africa there's the war with the Zulu king, in the end it results in a treaty in which all the property and all the rights of the people are turned over to a new colonial power or a settler power, right? So Israel in the end is both a violator of international law in the same respect and a creation of international law. Because you have to have an idea that the United Nations creates a state in another's home in the beginning, right? The inception of Israel, of course, is the first act almost of the United Nations, which is to create the partition plan for Israel, and then accuse the Palestinians for not accepting what is a completely unfair treaty, right? And I don't know whether people have been following, but there's a new idea to treat the Nakba as a legal phenomenon, right, which has been subject to, shall we say, censorship by even the Columbia Law to some extent, where they actually took down their website to form it. So this is one happening, but the issue, of course, is we can talk about this for much longer, is what replaces it. So we have the rubble of international law, and the rubble of international law will, of course, be determined when people stop listening to it, when people stop following rules, because of course you cannot enforce a legal system only on gunboats. At some level, you need at least a majority of the people, with some outliers, to agree to some rules to follow, whether it's for trade, etc. So at some level, something has to replace. You cannot have a vacuum.
In a way, there was the first, that's the important thing. First, there was a decline of the idea of sovereignty. Okay?
Yeah.
So international law starts on ideas of sovereignty, the Westphalian ideas of sovereignty. Of course, it was only the sovereignty of the Western Bloc, but was still the idea of the sovereign state. Then, it developed, and the critique on sovereignty started to unfold also among scholars, not just among, practicing international law, but also in legal theory. When they said, oh, international human rights are stronger than sovereignty, for example, and there you go, you can bomb Belgrade, saying that Milosevic was violating international human rights, and he said, but he's kind of within his boundaries, say, well, it doesn't matter. And that was the first time.
Yeah.
That was really the first time. Then the same thing was done with Gaddafi, right? Later on. Then, they started saying, well, but the idea of sovereignty cannot work from a variety of other perspectives. You said, blah, 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 blah. So we go to a point, NGOs should not only states, but also NGOs and also corporations should be actors of international law.
Right.
That was another step that was very cool 10 years ago. 15 years ago, it was like, the fancy trend in academia in the United States will say, oh, the new non-state subjectivity, and can we imagine a system in international law in which large NGOs are also, part of the assembly?
Yeah.
And so these are all kind of things against sovereignty. And then, but what happened there is that the people did not understand, those international law people did not understand that sovereignty itself is like law, in the sense that of course it is the sword. Mm-hmm. Of course through sovereignty you can do a lot of bad things if you are the bad guy. But if you are the small guy, sovereignty is the only thing you have. So it's a shield. Yeah. You see, if you are Bhutan, or if that's the shield against having someone from outside telling you what should be the values of your people, So it is a very protective idea.
And democratic.
And democratic idea in a sense, self-determination, look at Crimea, all these kind of things are part of the same narrative in which you go against the sovereignty, in fact, you go against law.
See, a large part of international law problem was a complete, almost avoidance of colonialism as something continuing. Because when you avoid colonialism and the concepts of colonialism, then you don't look at how the system is developing and what is happening in it. So today, for example, everybody says Nuremberg. Excellent. Everybody says Tokyo Tribunal. These are the foundations of modern international law, right? Lemkin, Lockhart. These are sort of what we have as foundation stones, right? There are problems with principles of crime created, etc. But who's against Nazis being tried in a tribunal? Nobody should be against that. It's like not loving little babies. But the problem, for example, I know I've studied this more, but if you go to Japan, which is very much part of the modern world now, they don't look at the Tokyo Tribunal as a triumph of international law. There is a guy called Justice Pal, who was the Indian judge, who wrote a dissenting opinion, which was never published as part of the official record, who has a statue in Japan, which is still worshipped. And when Abe, who was the Prime Minister of Japan, used to come to India, he used to go to his house to pay respects to his descendants. So that is their perspective of international law. Not that...
And then he was killed.
Oh yeah, then Abe was killed, right? And what does he write? Abe is not, Nepal is not writing something which is completely extraordinary. He's saying, what is the violation of the Paris Accord? It was never a criminality. Okay, that's a technical argument. But the more political argument he's making is, how can you have a war of aggression against colonial subjects? How can Japan be accused of invading Philippines or Burma when they're already colonies? So it ends up, which is of course true. You can't have an aggression against a colony. You already are colonized. So the entire edifice, everybody, ICC, everybody ignores that part of the foundations of modern international law, right? Humanitarian law, etc., which is what the United Nations is built on, which is of course, chapter 6, chapter 7 of the UN. The Security Council, of course, becomes interesting because it is, as you said, sort of a musical, when the musical chairs stop in 1945, whoever's left standing is supposed to be left standing and can't be ignored is put in the Security Council. And a large part of what a new system that should be built is people asking to be let in. So in South America, we have Brazil saying we should be part of it. The major focus of India is we should be part of the Security Council, etc. However, that is to some extent perhaps perpetuating the problem, not changing the rules as they exist. Saying if you just let us in, we should be fine. Now, of course, there is a difference because China, of course, is already part of it. But remember, many of these countries, Brazil perhaps being an exception, have never had a colonial past, have not really invaded other countries, right? So China is the first country sort of for 500 years, 600 years, who's not developed through colonial conquest. Everybody else has developed through some colonial conquest. So there is a difference in having them there, but the question then becomes, do we need to change the very foundations of the rules? And it's interesting, I was talking to Professor, but you can come in on this, is 29th of June was the anniversary of the Panchsheel Accords, which of course did not stand even 6 years because there was a war between India and China in 1962 and still is the largest.
So give us some background on that. Yeah.
So 1954, what is then Communist China, PRC, is not a member of the Security Council, and the Republic of India signed the Panchsheel Accords. Panchsheel literally means 5 principles, right? And I won't go through all of them, but essentially it is peaceful coexistence, mutual respect, and respect for each other, sovereignty, right? That's what it's founded on. They signed this accord, and the idea is that of course, a lot of people on the right in India today question whether that led to China being able to come into Tibet and take it and make it part of mainland China, because that happened after that. And the idea was that then went on to become the foundations of the non-aligned movement, which of course starts here in not very close, but in the Adriatic Sea. Tito's Yugoslavia, and the Brioni Convention, which then is the Bandung Conference, which basically is a group of countries which say we adopt these as a system of international law. Today nobody talks about the non-aligned movement, but it was the majority of the world at some point which said we are going to be equidistant between the Soviet Union and the US. What that meant in practice, which is of course again relevant today, unlike bell bottoms, was that nobody would join Warsaw Pact, NATO. There was at one point, nobody remembers this, the Southeast Asian Treaty Organization and a Central Treaty Organization, which was Iran, Iraq, and one other country perhaps, Jordan, and the US of course. So there were all these offensive pacts around the world. So the idea was to stay out and be equidistant between the pacts.
They had a large impact also on official international law,
right,
on the Suez Crisis.
Exactly.
Because and that was actually interesting because it was reestablishing the central position of the General Assembly compared to the Security Council on that resolution that was called United for Peace. Which is a resolution not of the Security Council but of the General Assembly that was introduced when the Brits and the French moved on Suez. They were stopped by
because of the nationalization of the Suez Canal.
After the canal, and they were stopped by the non-aligned countries and the US to gain, the mind of the non-aligned countries, saying, no, stop this thing.
Yeah, and there was UN peacekeepers in Gaza and in Sinai, etc. Because of that, because the Soviet Union, of course, vetoed the Security Council resolution, and of course that was also based on re-establishing economic sovereignty. Then, of course, there's the war with China in '62, Indo-China relations and Chinese-Soviet relations go south, with manner of speaking, and this idea of non-aligned movement continues, but it stops to lose the primacy of international law, except the new international economic order, which everybody seems to forget about, which happens in the 70s. On 29th of June, the reason I was mentioning is President Xi commemorates in China the Panchshil principles and says this is an articulation, and everybody in India is like, no, they will never live up to it, but at least he articulates on the anniversary, now what is it, 54 to 2024, on the anniversary of the Panchshil Accord, and says this has to be the bedrock of modern international law. So there is an articulation of an alternative vision.
Which is based on re-establishment of pure sovereignty.
Yes.
Which is basically the model on which the BRICS seems to operate, right?
Exactly.
So a complete respect of the decision of the leadership, which is why the Western say, oh, that's not democratic.
Yeah.
This is dictators that make deals between themselves. You scratch my back, I scratch yours. But in fact, that is not really the case. The case is that through reestablishment of sovereignty, you can move some steps in the direction of reestablishing the system of international law that emerged after World War II.
Yeah.
And some of these countries, including South Africa, they have shown some respect of the institutions of international law by moving against Israel in the court, right?
Well, so there is. So India has, of course, been laggard, I would say, on the issue of Israel, because the Modi government is very close to Netanyahu. They walked on the beach together in Israel, very nice, holding hand in hand. But on some other things, it has walked the talk. So it still respects the two-state solution. We recognize Palestine is called for ceasefire, but more importantly, and this is completely unnoticed in international legal fields, in the first term of the Modi government, they cancelled all bilateral investment treaties and said that this model of enforcing a privatization of international law was not tenable, which is again, one of the strongest mechanisms of enforcing this idea of development and protecting of capital is basically a modern version of the Hull Doctrine. So they cancelled it and they said everybody needs to renegotiate.
So that was Modi did that.
Modi did that. And so that's an important articulation of economic sovereignty, which is now trying to be followed, and OECD is very much against it. And I know that the free trade agreement with the European Union has been held up because of negotiations on the new bilateral investment treaty to be signed. And so that's the major sticking point. And bilateral investment treaty, which people in my class will know, is this transformation of a private contractual right into an international legal obligation on behalf of the state. So it's an extraordinary legal mechanism which came in the 70s as a reaction to economic sovereignty and what was considered expropriation.
Yeah.
Okay,
So let's open
yes,
the floor.
that's a good idea.
Hello, my name is Matteo Basei, and thank you for your content, and I totally agree. And I would like to ask how the 11th 2001, the attack to the Twin Tower, can be put in line with the chronicle history of this analysis, and if there is any connection, or if it's totally out of the blue, totally no connection.
What would be your take on this?
I mean, for me, I'll tell you my issue. Till 2001, the myth that human rights survive emergency was still alive. Everybody was saying, okay, you have war, but you must remember human rights. The state of exception was not normalized around the world. 2001, the center, if you want to call it, of the of international law, which is the US, said, oh, we are now in a state of exception, and now we normalize the reaction to the state of emergency in a state of exception. And then that became the normal. So now we just constantly live in the state of exception. The war on terror, the war against terror, the war on Russia. So everything is an exceptional measure because everything is exceptional. So we move from some attempt on normality from, or at least preaching normality to a complete international state of exceptions where rules can be bent or set aside whenever you declare an emergency, which was of course an idea that Ugo will talk about even during COVID. This was an issue.
Yeah, but it takes I don't know whether there is a strict connection, but there is a connection for sure on this idea that it was also part of the Cold War polemic between the Soviet bloc and the capitalist bloc. They were looking at each other and saying, look what you are doing to your dissent, and the other would say, look what you're doing to the black people, and look here and look there. So there was a lot of pointing to each other with large emphasis on things that were basically shames on both sides. But that created some dialectic that created some sort of consent on certain kind of foundations, through dialogue. That is part, of the whole idea of new international law and stuff emerged on that kind of Hegelian dialectic. Yeah, on this. After 2011 to 2001, I think that the United States completely lost the power of discourse on international human rights. You see, because the power of discourse on international human rights was saying, look, we in the West, we respect certain kind of rights. Women and men, these kind of things, this whole narrative about how we are respectful of human rights in the West. And that was deployed in order to show that in the rest of the countries the level was not the same, and therefore there were some objective reasons why we were superior. Okay, that was basically, I think, it seemed to be what ended at the end, in the beginning of this millennium, because there is nobody that believes right now that the United States respect human rights. I don't believe there is that belief. That was something that appeared very clearly, probably also before that, if you think of Genoa in the G8 meeting, So the idea that the West is very good in respecting human rights where the others are not, is just not credible anymore at the global level, and this will probably change a little bit the things.
Yeah, and the other event, just to add to it, if you want to put a date, is the economic crisis or the debt crisis or the financial monetary crisis of 2007-2008, which changes some of the rules of international financial markets and financial openness, etc., is a second event, which of course starts to shift economic power also between countries, right? Which is not studied enough, but it's really the start of China being a truly alternative center of economic power in the world, right? And so that happens after 2008.
Yeah, but also probably after 2001, because the very same year of the Twin Tower was also the entrance of China in the World Trade Organization.
Yeah.
So that was already kind of a shift in economic power, which is quite consistent. Now, to me, what is fascinating now is seeing how the United States seem to be capable of holding a very tight control on Europe on the one hand, and on Japan on the other. So basically the post-World War II posture, of the United States throwing the bomb and being, so to say, the emperors of this part of the world is still in some way holding politically. So this is one thing that we have to consider because it's very dangerous. And on the other hand, in predicting what might happen within the BRICS country, that I think we need much more knowledge about about conditions that at least I don't feel confident in
I
having.
mean, I must admit that I've been skeptical, and I've expressed this to Ugo, about the imagination. Of course, we have.
You were skeptical until the declaration.
No, I'm
of
skeptical. I see a
No,
little
no,
bit
no,
of
no,
hope.
no, you were
I see
skeptical last
hope.
week. Now you change your
Yeah.
mind.
I said I see hope in Z. But
Okay.
but I'm skeptical because of course there is the third world, third world approaches to international law. There's Chimney, who's been writing
Yeah.
about sort of new way of looking at sovereignty. There's been Upendra Bakshi. There have been scholars who've been writing about this, but they have not been able to breach sort of the mainstream of international law even now, but also not been able to breach the public discourse of international law within their own jurisdiction. So it's not that Chimney's ideas are considered. If you read the think tanks which are close to the government in India, like ORF, their imagination is limited to joining the Security Council, right? Which is it is not reimagining it. So which is why I'm interested in whether Z's pronouncement of Panchi, which of course had a negative reaction in India, is something which leads to a change. Now, South Africa, on the other hand, is still very much in the national liberation mode of saying that no, the Palestinian liberation is something like our national liberation and the workers' right. If you listen to the foreign minister of South Africa, she's very much on the mode that get out of your armchair, all workers' rights are our rights, etc. So they are still articulating a alternative vision because perhaps they are closer temporarily to their national liberation movement, right? And Brazil, of course, depends who's there, Lula or Bolsonaro. So it's very different. And for BRICS to come together, there will have to be at least leadership and an imagination. So if Zeke follows through and says, okay, we're going to stop, having a little conflict with Philippines and a border conflict with India, etc., and we're going to have the larger interest in mind, then we get into a different space.
No, but also I think that also internal agreement on the national interest is that what might change. Because you see, until not much time ago, there was always a party within any one of those countries that said, well, we are better off if we stay aligned with the US.
Mm-hmm.
Okay? So the political discussion was whether the local country would be better off in being in really following the US or finding its own way.
But that I think in
So
India
now
is consensus, is non-alignment.
Yeah.
In India, the consensus is always non-alignment.
Yeah, but then that's not really Modi, right?
No, but even
I mean,
Modi
Modi was a
can't
super
reach
neoliberal,
that.
yeah.
Even Modi cannot join NATO. He
No.
can't send troops. He can't go to that extent. He can, of course, stop buying oil from Iran, but he will still make trade deals with Russia because that's the historical legacy of international law in India. So in Iran, he stopped buying oil because of the sanctions, but India is the largest buyer of Russian oil, right? So that relationship continues. Whether he likes it or not, that's the sort of instinct of the state.
Yeah.
Right? China, I don't know.
One more question here, please.
As going back to the conversation where it ended, what do you think that is because of the fall of international law system, the globe is seeing this increase in nationalist ideologies all across the countries, and if you are affirmative on this statement, then do you think this is maybe unfortunate need to create an alternative of the international legal system, or there is not even a need of creating an alternative to this system because we just might need another power block?
Law lives on power,
Yes,
That's
because-
true of law, it is true of international law.
Mhm.
So it doesn't seem to be a scoop that you need to, that it emerges from, developing and changing power ratio. And probably what is really going on now is that the West is reduced in numbers and aging very fast. And therefore its capacity to grip on the world is so much connected just to violent technology and to weapons and to weaponry of a variety of kinds, that it doesn't hold the hegemonic idea of coming up with a narrative that is persuasive. Because, global relations, international relationships are based on might for sure, but are also made on narratives. Okay, and so and the narrative of the West is now very, very poor. It's not anymore a narrative that is so seductive as it used to be before. So clearly, it seems to me, before having a new order emerging, there has to be a significant and very painful fall of the previous order. I don't think you can imagine international relationships as some sort of reform patterns, in which politely people say to each other how would be better go in the general interest. It's not going to go that way. It's going to go probably in the way of a pretty serious clash. What is important is to have alternatives in mind after the rubble is to be taken away, because I don't think that any scholarly discourse can avoid the material forces of history to unfold in a given direction. I don't believe in that. I believe what ideas can do is to help in rebuilding something that allows us not to go more and more in the same mistakes. But material forces of history are.
I mean, some of it is already happening. Like we had the crisis at the end of 2022 in Sri Lanka, right? Which is of course unfolded into the fall of the government, etc. But traditionally, what would have happened is that the primary lender of rescue would be IMF. There would be a structural adjustment program. The country would go through all this, austerity, etc. But now the IMF doesn't have the same power, because there is China, which is bilateral lender. There is India to a lesser extent. So now you have a reduced power, just as an example, right, of who can exercise control over the readjustment of the debt. And China is playing a different kind of role, because it doesn't want it to be a negative perception that if you build all this infrastructure using Chinese debt, we're going to come in and take it over, because this is going to happen. What's going to play out in the next 5 years all over African countries is the sort of coming to fruition of Chinese debt, which has been built on infrastructure. And how China acts on that debt is very important as a normative function on how it deploys its debt power differently from what the West has, which has been to send in the IMF, open up markets, privatize, austerity. So that's been the traditional model. Sri Lanka has avoided that because of the multipolarity of debt, right? So we're already seeing some examples of multipolarity.
Yeah, but Sri Lanka went through a huge impact of austerity right at the beginning. Then
it wasn't austerity as much as COVID. Free fall of currency, etc. But the IMF introduced programs have not happened, right, to the same extent. And the government fell, of course. Sorry, you had a question in the back.
I don't know nothing about the law, so forgive me. But I don't know. Before you were talking about state of emergency.
Mm-hmm.
So you think it's possible that someone put down on paper emergency law, creating a law precedent based on the trial of the human rights? Not now, but in the law it became a precedent. So you acting like that for years, and then it became
normalized.
Normalized.
No, I mean,
And
this is what we live in.
Someone can put down this as a law. It's possible, or
Who was the Nazi theorist? The sovereign declares what is an emergency. It declares a response to an emergency. Sorry, Carl Schmitt, right? This is the law of authoritarian. You declare what is an emergency. You declare the response to the emergency, and the court should not be able to question it. And that is what we existed during COVID. We existed during the war on terror. We exist on the war on piracy. Choose whatever conflict you feel like picking up, and everything is the law of emergency. We are constantly in a state of exception where you cannot question the decisions of the executive based on any legal categorization. Today, what does Israel say? Israel doesn't say, oh, so we have a state of emergency, don't question us because we must deal with the emergency.
Yeah, but for example, so just to answer to your question, in Italian law, I mean, this was discussed in the Constitutional Convention, and indeed we do not have a state of emergency that is constitutionally declarable in Italy. We do not have that. We have a procedure in extraordinary cases to for the government to use, decrees that have force of law in the Constitution, but we do not have a general state of emergency except in the declaration of the state of war. So, but it doesn't work because then you see what happened during COVID, and clearly, no matter what was the constitutional law on the books and whatever was the opinions over constitutional law of the scholars, it occurred anyway, and legal scholars aligned. So it was just
we had
because it was a real state of emergency.
Yeah.
You see, the real state of emergency you cannot predict it by saying there shall be no state of emergency. There shall be this and that. No, it doesn't work that way because then it's not a state of emergency anymore. It's like the moment in which you try to codify and to normalize it is not a state of emergency anymore, and therefore it's not going to hold. You see, it's just the tension between power and law in a way. The state of emergency. When is a mere power structure that determines the processes and not the legal structure.
Yeah.
Last one or two? Amen?
Mike.
Okay,
Okay.
please.
Whatever. You go first.
This is a very polite group. I mean, first,
Too polite, I know. So, first of all, thank you, Avi. It's great to have you here, and thanks
Thank you.
you and Ugo for this intriguing, thought-provocative dialogue on the marginalization of international law. In one of your replies, you mentioned possible alternatives to the current international order. And my one is a brief follow-up and a question on the future of possible future of international law, because international law and the international order overall considered has undergone some form of criticism for quite a long time now. You, Avi, mentioned the trail to third world approaches to international law. There are the new approaches of international law. You can mention Koskaniemi rather than David Kennedy, who argued that somehow the structures and narratives of international law themselves often mask power dynamics and perpetuate inequalities, and the current landscape is a proof of that. And you mentioned that the UN, and it's right, the impotence of the UN in the current context of war, so Gaza and the Russian-Ukrainian conflict, which is, of course, hamstrung by these obsolete mechanisms of veto powers within the Security Council, which, by the way, it's a post-Second World War relic that should be reimagined, is somehow the crystal clear example of the marginalization of international law. But then you mentioned the new dynamics, the BRICS countries, the possible re-establishment of the sovereignty principle. So do you think that these dynamics may mirror a broader patterns of resistance and may lead to a transformation of international law, international order in the future? So that is my question.
I mean, it could always make things worse, no?
Yeah,
I mean, it's not necessary that things improve. Always. I mean, we as Ugo mentioned, we first, the old will have to, unfortunately, be crumble, perhaps even violently. Who knows? There is not a clear path to a new order. But I don't know.
I think it might, what might happen. I mean, if I had to bet. I mean, unless there is a conflagration, But I mean, if the current state of World War III remains, that is to say, you have different theaters, and maybe there is going to be another one or two to be opened here and there. But I mean, if the situation remains awful as it is, but not to the point that all the world burns, I I think what might occur is that on this whole narrative on the pluralism in international law, because we have to consider that until 15 years ago, I remember that everybody who was teaching comparative law would begin his class saying, one thing is comparative law in which you have a plurality of legal systems very different from each other to, compare between themselves. One thing is international law, which is one order, okay? It's just one universal order that we are building together. Then the critique goes, well, one order. It's not one order. It's the order of the West and the colonies that is imposed on everybody else. It's not really one order. And more than that, there is also the idea that even international law is interpreted in such different ways that we can talk about comparative international law. The international law as interpreted by the Bolsheviks or the tradition in the Soviet Union created a conversation in international law that was very different from the conversation in international law that was going on in the United States or that was going on in Europe, and therefore you could imagine to compare two different kinds of international law. And that was comparative international law, so you have this idea of universalism and just one system idea just falling apart, okay? So what I think could happen is a variety of localized systems of international law, okay? So relationships that are in the nature of international relationships, in the different blocks, that link together countries of those different blocks that share some kind of ideology and some kind of power structures, creating their own system of established international law within the blocks. And this is why I'm looking at the BRICS as something interesting, because the BRICS maybe will become a currency, has already became a central bank, might become a system of international law, might become a system of international law, linking together those countries in a more stable way, maybe having a BRICS court, that right now is just very procedural, because being completely based on sovereignty, what happens is that these guys meet once every year or so. In preparation of that, there is a lot of Sherpa works, to kind of prepare the dossiers, but ultimately, if you don't want to agree out of your own sovereignty, you just don't agree, okay? Nothing occurs, which is very different from Europe, for example. It's very different from many other international organizations. So maybe, the BRICS will become an international organization a little less informal, and if it does so, will produce a system of international law of some kind, And so there could be, an evolution in the terms that you could imagine like a few decades in which we have a variety of systems of international law, to the point that then at the end maybe one or something common occurs again.
But there's one critical element to this. I know I'm running out of time, but de-dollarization.
Yeah.
Right? Till the dollar remains, which also extends US regulations or Lex Americana to the whole world, this is an issue, and the only country which is inadvertently decoupled from the dollar is Russia, right? Because they were forced to. They couldn't deal in dollars, so they've been forcibly decoupled, but maybe it's a model, so de-dollarization. And I'm even more hopeful than BRICS on the African Union, because now you have, for example, passportless travel in African Union, or at least in East Africa, that's a proposal. There's a lot more integration of a very different kind, some kind of judicial response on human rights, which is working in a manner of speaking in Arusha. So the African Union, at least as an articulation of a bloc which is not based on capitalist formation, is functioning and developing integration very differently from the European Union, but it's, for me, more interesting than BRICS even, or more advanced than BRICS. in his articulation. Of course, that requires Ethiopia not to have a conflict every couple of years. I keep telling these guys, you know, every 20 years, the Ethiopians make the mistake of attacking some version of Tigray
It's unbelievable. It's
yeah, they repeat the same mistake, then 1 million people die, you know, and then we are back to square one. Yeah. Sorry. Yes.
Thank you very much for the presentation on the very fascinating issues. You indirectly tried to a little bit address my questions, but I will try to ask it, and so that you give much emphasis to it. You guys said a lot about, for example, absence of coherence, absence of patterns in international law, many resolutions made, many vetoes, and we're seeing the remedies of international law is getting weaker and weaker, being marginalized, and a lot of things is being happening on international law, and it has already become a vehicle of the imperialists. So my question is, just how about thinking the growing regionalism, just like what, for example, you try to pick up now. I yesterday tried to a little bit pick up on our classes. There is, for example, we're seeing that there is this Malabo protocol, which is made in African level and giving the criminal jurisdiction to African Court of Justice. And many African countries have already submitted their notices to withdraw from the Rome Statute and other things. And so that the ICC jurisdiction does not work on them. For example, South Africa and Burundi have already submitted the notice. And so, if international law is not working well, the remedies of international law, ICJ made decision, resolution being made, nothing is being enforced. How about thinking of growing regionalism? For example, if, for example, we try to stick to, for example, as you say, I think much about that. For example, if we try to strengthen regional institutions like African Court of Justice, European Court of Human Rights, and other things, strengthening these regional institutions will may soon time take over the international law, which is very unipolar and dominated by very few countries. So why don't we think the alternative ways? From if we see currently, we see international law failing to give any remedies to the world. Genocide happening, war crimes happening, every forms of human rights violation happening, and then international law is not living up to its expectation. So what should be the reaction of the states towards the international law which is not functioning? It's not functioning. International law is a fiction made by humans. It's not a God-made laws. Yeah, just it's a fiction. So what should be put in place? What should be an alternative system that you guys as esteemed international law scholars propose of the law? Just everyone is losing hope on international law. Even until we get tired of hearing, you get tired of even now. Resolution made every day, nothing is enforced. So we get tired of hearing resolution made, vetoed, and then this thing. And countries, young scholars, just losing hope on international law. So what should be a remedy? Either you guys recommend, I don't know, the growing regionalism, like maybe regional courts or regional human rights system, regional systems working out well, or what kinds of system that you foresee or anticipate to see in the world in the coming years? What is the future of international law?
That's the question we are trying to address. But it seems to me that what we can try to do is to learn something from what happened on domestic law. Okay, so for example, in domestic law in Europe, there was a long period of time in which modern law was about just a single class society. Okay, the bourgeois society made of owners were the only subjects of the law. Okay, the Napoleonic Code is very, very clear. And then, you know, by the end of the 19th century, pluralism of classes emerges. You know, the working class gets subjectivity, you know, all sorts of things change. And the system of the just one class legal system, which was the bourgeois Napoleonic Code with this idea of a centralized order, collapses for a long period of time and some kind of legal solutions emerge. Social functional rights, all sorts of development of welfare institutions, development of public law as opposed to private law, development of labor law as opposed to contract law, So there is an evolutionary attempt to include within the scene of the law what was not actually even imagined when the law was framed to begin with, okay? So in international law, it seems to me that the same thing is happening, okay? We had a system of international law that was born out of the Westphalian system, of the Western European countries, based on their sovereignty of free countries, the global north basically expanding through colonialism all the way to global south. Then from a certain point, the 60s, basically maybe a little before with India, Africa in the 60s, in the 70s, you have new subjectivities. So these new subjects of international law, these new states, to me, are like the non-bourgeois forces of local and national law. Okay, so the desubjectivized parts that were not considered where the system was organized, that emerged from the bottom up and challenged the system of law by trying to enter into it and, de fact, torpedoing the very vision of a single class society. It takes time, and I don't think that the right way to see is, okay, let's sit here and imagine how the system of international law might look like in 50 years from now, with a bunch of international law experts or scholars that sit there with very good intentions for the future of the world. No, that doesn't work that way. History works through material forces that are not determined by the will of a single person. That's not the way history works. If you get War and Peace by Tolstoy, it makes pages and pages and pages showing that not even Napoleon was in charge of what was going on in the Napoleonic Wars. Mm-hmm. There were all sorts of material conditions of history that determine the ways in which each one of us operates in a system that is not understandable nor steerable by a single mind. So I would not even try. I can see some trends. The trends were the ones we were discussing, a re-emergence of sovereignty for sure, because sovereignty is protection, and it seems to me that within the re-emerging forces of international law, there is a sense that international law can protect you, and possibly that is true of it comes out of South Africa a lot, because in fact on the anti-apartheid movement, international law had a role, and therefore there is some faith in that in those countries, but it occurs very gradually, and it depends on the forces of the political spectrum to say what is going to happen. That's my vision, at least.
Yeah, and it is, as Ugo says, organic to some extent, but also to some extent, things were written in 1945 in San Francisco because there was a moment to create something very quickly, and that led to a system that was used to perpetuate a particular kind of development model and not consider alternatives, etc. So obviously a better system would have to be more organic, right? But international law is operating today. There's treaties even between warring parties being signed every day, whatever, we may have conflict with Pakistan, but the Indus River Agreement still works for the last 60 years, right? In terms of river sharing. So there's a lot of treaties are functioning every single day, even in very particular problem areas of the world. Yes.
Thank you both so much for this fascinating conversation. So I would like to know your opinion, talking about the using of human rights as a tool for violating of sovereignty of the foreign states. Do you think it will gonna expand so much that will be used for invasion of countries which, for example, don't recognize same-sex marriage or gender transformation, or go in this direction? can it be in possible future become a reason, a justification of, for example, I don't know, United States or some Western coalition bombing some African countries where it's not legal?
Yeah, I don't think it's completely untenable as an hypothesis. I mean, that was done historically for women for such a long time, you know, bombing a country in order to take the scarf away from the women or to, you know, enforce equality among sexes and all of that. That happened in Afghanistan, happened everywhere, happened as a justification in the media for Gaddafi. So, you know, of course, it depends how much consensus within the aggressive West emerges about those kind of different standards of you know, gender relationship, and how the declining West is actually capable to wage war and attack other countries on basis like that. Again, you know, it's just is a matter of political possibilities. It's not a matter of abstract conception. Certainly, from history, we know that that kind of ideological use of legal transformations has been deployed before many times.
Yeah, I mean, I'll give a small little example. Of course, it's not an invasion, but I'm a member of an international legal organization in which, as it happened in the last few years, some of our Algerian colleagues or lawyers decided that numbers makes you powerful. So about 300-400 Algerian lawyers joined the organization, and then they proposed that the next Congress of the 3,000 lawyers should be in Algeria. And the reason to exclude them was the non-recognition or the criminality of same-sex in Algeria. And as the executive said, no, even though you have the second largest majority and you may be warranting it because of democratic, you do not have the legal mechanism to have the Congress there. So that's a small example, but there will always be exclusions like that. You know, you are an exception because it becomes a standard that you don't meet. But you can go to Dubai where it is also banned. That's okay because they have money. So you know, there's always different scenarios. Okay, I think.
Okay, good. So thank you very much for your attention. Thank you, Avi, for your.